We're focusing on judges and witnesses, judging and witnessing. Our format will be to have a presentation, very short presentation by Balu on some of the themes in his position paper. Then we will turn to Werner Mensky, and he will have an elaboration of that theme. Then we will open it up to the other three panelists, and the audience will be in the second half, so your opportunity comes in the second half after the tea break. And I promised yesterday to give priority to the people whose questions could not fit into the last session, so I ask you to stand up at the beginning of the next session and you get the first questions. All right, Professor Balu.
It occurred to me, reflecting about yesterday, that some of the discussions were at cross purposes, or we were talking across each other. Because perhaps what should have been clear from the outset was not made clear, namely what exactly I'm talking about, at what level I am addressing the issue. So let me clarify 2-3 points from yesterday and then use that to take off for today. See, the first important thing is philosophy of law, understood in any sense of the word, is, for my purposes, for this position paper, quite irrelevant. So, such things as whether of legal positivism, legal realism, etc., discussions about what human rights are, what their foundations are, philosophically, they are completely irrelevant to the questions I'm trying to raise. If you add them, they'll only confuse the issues. The second equally irrelevant discipline, for my purposes, is general jurisprudence. That is, asking questions about what law is, what its aspects are. This is simply confused discussions without clarifying anything. They have their use, to be sure, in different places, but not for my purposes, because if you bring in either of the two, you'll completely confuse the issue. Now, these are the two things which I want you to keep in mind. The third point is, there are two other much more methodological points that were raised yesterday. One is, yesterday when I spoke about truth and falsity, the theme will keep running through both today and tomorrow. The question I'm asking to signal in the direction of a problem is not why someone believes something to be true. For example, people believed for a long period of time that sun revolved around the earth. They believed it for multiple reasons. So to ask why one believes in truths, whether gender questions are involved, ideological questions are involved, social questions are involved, cultural questions are involved. These are all, to be sure, important questions, issues for investigation, but that is not the question I am talking about. Now, one of the reasons why people believe in the truth of a statement, like sun revolves around the earth, is the belief that that statement is true. So my question is, what does it mean to believe that some statement is true? That is, what does it mean to believe that sun revolves around the earth? So I'm not asking why people believe in it. I'm asking, what does it mean to believe in it? This is what philosophers call as semantic question. That is, what does truth mean? Yesterday I was talking about that, and discussion constantly got confused by bringing in all kinds of sociological, psychological, cultural, gender dimensions, which on their own, to be sure, are important, but they confuse the issue without clarifying the problem. So this is something I would like you to keep in mind. There's a second methodological point, which is equally important. I think Farah was raising it yesterday, when she raised the question, what would happen to your discussions if we disaggregate India? I gave an answer, but that was did not quite solve the problem, I understood. India, or any group, is not an aggregate. This is what is known in social sciences as methodological individualism. That is, you believe only individuals exist, and everything else is an aggregate. So nations, groups, etc. are aggregates, and therefore post-colonials ask the standard question, who are Indians? This is not how I'm talking about it at all. Because I do believe, not abstractly, not as a philosophical point of view, that structures exist. And when structures exist, you can't disaggregate them because they are not aggregates. You can only decompose them. For example, water, if you decompose water, you get hydrogen and oxygen, which do not have the properties of water. Water is a structure, H2O. It contains of two molecules of hydrogen, one molecule of oxygen. You can't disaggregate it, you can decompose it. So India that I talk about, Western culture that I talk about, the West when I speak about it, they are all structures. So you cannot disaggregate them. Indian is someone who belongs to who is part of Indian culture. Indian culture, I have shown how it should be viewed as a structure. Now why is that important? Is because it will allow you to ask questions, to solve problems, to explain phenomena and predict them, if you think explanation, prediction are different things, to falsify hypotheses, depending on your philosophy of science. So I'm using these as theoretical terms in a hypothesis to solve problems and explain and predict phenomena. Therefore, standard questions that kill audience and kill discussions, which mostly postmodernists and postcolonials raise without understanding what they're asking, or simply inapplicable. Should you use them, you will simply confuse the discussion. Of course, you might want to confuse the discussion, that is your privilege, but as the author whose idea said at the moment of discussion, I'd request you not to do it. Keep these things in mind today also, please. So, no discussions about what law is not, what its parts are, etc., etc. Because they're totally irrelevant to the points I'm trying to raise. So at what level, and therefore methodologically I'd like to suggest, I'm only going to talk about that because I'm going to presume that you have all read the position paper. Now it's possible you haven't, but then I don't know whose misfortune is it. It is mine or yours, or maybe both. Because the idea of this conference is you have a position paper, you read them and come and we have discussions about that. Today, the discussion, in my eyes, ideally speaking, should take place at the level of the following kind of question. First, let me give you an example from philosophy. There is something called a transcendental question. For instance, Kant, he was the one who began this sickness amongst philosophers, thought that there were two kinds of statements, actually four kinds, but two kinds of statements, called analytic and synthetic. And he further classified them differently as those that are prior to experience, called them a priori, and those that arise from experience, a posteriori. And then he asked the famous question, his critique of pure reason, how is synthetic a priori statement possible? Now this has been usually called the transcendental question. That is, it raises questions about the possibility of the existence of a phenomena. of a phenomenon. That is, how is it logically possible something exists? What allows for its existence? Or, put it a little less strictly, how can we conceptualize the possibility that some things are in existence? So the question I'm asking here is, today, about the role of the judges and the role of the witnesses. The question, in transcendental question, is simply this: how is such a massive, I mean massive, corruption of judiciary possible in the last 60 years in India, 65 years? It might be no exaggeration, perhaps, to say that there's no judge who is not corrupt. Perhaps it is also no exaggeration to say more than 95% of the judges, especially in lower magistrate courts and higher and even Supreme Court, are basically illiterates as far as their own jurisprudence is concerned and about law is concerned. Now, this is not Balu's statement. This is what really concerned people themselves say. The second, of course, is something which records have massively demonstrated, which today we see in front of every courtroom building, is that how is it possible that witnesses in the court benches are willing to swear on anything and tell absolute total lies? If you go to a courtroom, you will see surrounded by hundreds of people waiting for a job, and the job is to come and testify. And the example I give you in my paper, what the police do, is very, very normal. I have heard at least about 100 police officers talking about such things. And of course they say it is in the name of preventing criminals from disturbing society. So the question we need to ask is, how is it possible? There's a reason to ask the question, because most of the time you come across really third-rate, or not even that, fourth-rate psychological explanations. Indians are immoral, Indians are simply corrupt, Indians are weak, Indians are this, Indians are that. Fourth-rate psychological analysis. Or some profound-looking things like, say, oh, that is because of colonialism, or attribute them intentions, or justify it, especially post-colonials love to justify it. They call it resistance or something or the other. Immorality is always, if ex-colonial subjects do it, it's supposed to be something fantastic. It expresses their resistance, it expresses whatever they want to at that moment find. Now these are good, perhaps, not even that according to me, it's a coffee shop talk. But they don't have place in a scientific conference when we have to understand the phenomena. So the question is very simple. How is corruption of judiciary and witness possible, and such a massive scale? Don't give examples of judges being corrupt in Europe and America and witnesses coming and lying. We all know that. We are not idiots. But this is a massive social phenomenon. That's how we are treating it. Now this question requires a conceptual logical answer. And I show how both the figure of the judge and the figure of the witness is understood in India, that it makes total arbitrariness on the one side possible. Anything the judge says is, as many people put it, is the law. The judge does not say what the law is. It's not his business to make law. But nevertheless, so rules are rules. So whatever the judge says, and judge does whatever he feels like doing. So if he can do whatever he feels like doing, why can he not accept money and just pronounce whatever he feels like pronouncing? So this in total arbitrariness in legal judgments characterizes Indian judiciary. And that has to do with how, in this framework that we are in, the cultural framework, we theologically loaded concepts from law have been understood. There is no other choice. The same thing applies also to witnesses, because we have no idea what it is to swear an oath. And why it should not be, as I said yesterday, why is it a bad thing to lie? It's not obvious. Not surely because Christianity says so. Christianity has said many things. For example, it assures me I have a permanent seat reserved, a hot seat in hell. Well, it could be true, but I'm not worried about it, as you can see. As I told the bishop yesterday, I'm not a Christian. And I can add today, I don't think I'll ever become one. So if this permanent hot seat is guaranteed for me in hell, so be it. But then its pronouncements about the value of truth and falsity are at the same level. I don't see why truth and falsity are necessarily moral predicates. I haven't found a single philosophical argument in favor of that. It is interesting to know, many have written about truth, philosophers, but hardly any has written about falsity. In fact, we don't know much about what falsity is, philosophically speaking. Anyway, that's a side issue. So in other words, the question I'm asking today, for which I put across some considerations in my position paper, is how is this massive corruption of judiciary possible? And I don't want third-rate, fourth-rate, psychological, sociological, half-baked political explanations for them. We need to understand something about the structural reasons for that, and that, I believe, is how or what happens when a foreign system is implanted on a native, indigenous legal system. Naomi, ladies and gentlemen, I thank you.
At the risk of annoying my host, I beg to disagree. If your argument is that there is massive corruption in India today, you are actually posing before us a very sociological and political and what have you question. We cannot avoid to discuss these kinds of structures that you put before us in all sorts of interdisciplinary ways. It cannot be done purely through a particular variant of philosophy or something. And you're saying philosophy of law is irrelevant? I'm really puzzled. And general jurisprudence is irrelevant? Of course we need to understand, first of all, what is meant by the simple term law itself. Because in a moment I'm going to take us back to Sarah's session that we had before lunch. So here I've left for people to note, if you like, the website address, because on that website address are all my writings, which you can download for free. So quickly take this note down if you want, while I speak a few more things. So I take the point that we want to focus today on these dramatis personae, the witness and the judge. And I think what we need to be aware of, we need to analyze the activities of these two dramatic persons in a particular field. And that field is a structure. And you mentioned the word structure yourself. And we have to analyze, I think, that structure and understand better what is going on in this particular structure. And in fact, it's not a particular structure, but it's a plurality of structures. So your paper that we have before us here in my reading is too focused on Western evidence and Western perceptions, Western lenses, if you like. And I think it overlooks some important aspects of, however we call it, indigenous, Indian, Indic, what have you, local phenomena relating to the activities of witnesses and judges that I'll show you in a moment, I think, have been left out because of the discussion we had before lunch, because of this colonial consciousness, this particular pattern that you identify of maybe not just distorting, but maybe deliberately ignoring or deliberately forgetting or blackening out certain types of law. Because when Sarah and the other people this morning talked about Gandhi, Nehru, and you could mention Ambedkar and others, you realize they're all lawyers, okay? And so all the time we're talking about the activities here and the colonial mindsets of people who are trained in London, who have trained as barristers, who've been brainwashed into a particular type of legal education that I have resisted. I did not go to bar school. I should have, but I didn't. Yeah? And so I have spent my time looking at other things. And so I think the first question we need to ask, so when we want to analyze witnesses and judges in the Indian scenarios and structures, what is the nature of this drama in which these two persons here are taking part? And the nature of this drama is, I think you might agree with me, we imagine a courtroom. But why do we immediately imagine a courtroom? Because a witness and a judge, the choice of words suggests formal legal processes, formal legal proceedings. But the ascertainment of truth and falsity is not only an issue for courts and for judges and for witnesses. It is an issue for every single mind, for all of us, all the time. And so it's a much bigger issue than simply court proceedings or something like that. So the scenario in which we are dealing here with our witnesses and judges, the drama, is actually a failed scenario, first of all, of self-controlled ordering. And the self-controlled ordering is dharma. Dharma has failed. The extra-legal process of solving a problem did not work. Something had to go to court. Something has to be resolved at a higher level. An individual has not sorted this out for himself or herself. If you know a little bit about the sources of dharma, you will know that the fourth source of dharma is atmanastushti. Individual happiness, individual satisfaction that I'm doing the right thing. That has failed. And so something needs to go to a different level. Yeah? And so let me show you first, because I do not want to spend too much time on things here, just some pictures. And this relates also to what we talked about yesterday and what we talked about earlier today. And Balu may say this is not relevant. I believe it is very relevant because we have in the world only basically 2 or 3 types of dramas. We have legal systems that claim to be uniform. This is typically Western laws, English law, French law, German law, what have you. One law for all, we say. But of course it's not true. Belgian law is not one law for all. You have so many different types of laws in your system too. Yeah? And so the critical tool in the management of legal systems that claim to be uniform is actually the power to make changes, the power of discretion. Now, Balu, you are seeing this discretion as arbitrariness in the Indian system. But even in the Western system, this power to fine-tune, to make sure that an imbalance is corrected, is today the critical legal power that lawyers, that judges, that legislatures have to make better justice, to try and achieve better legal systems. And we're beginning to understand this better. We did not a while ago. So can you see type 1 is all these European and North American legal systems. Type 2 is basically when you have US law, Canadian law, Australian law, where you have some Aboriginal group that has some special provision. Ignore that. But we are in type 3 here in India, and many of you this morning were in sessions where you were concerned about personal laws, Muslim law, Hindu law, the coexistence of all these different types of systems, okay? And that is what you have all over the world, in Asia and Africa and Latin America also. And this is the type, the scenario in which our dramatis personae here are acting. So it depends whether the witness is a Hindu or a Muslim or a Christian or agnostic or whatever. It depends maybe even whether the judge is a Hindu or a Christian or a Muslim or something, but Indian judges have to know everything. Our judges in England do not know everything. They know only English law. And if an Indian case comes before them, they need an expert. Your judges have studied Muslim law, Hindu law, all sorts of things. They have to deal with these cases by themselves. They have to find truth by their own devices. Okay, they can call in some friends, some experts or whatever, yeah? But qua office, they are tasked with finding the truth, not with being arbitrary. So, this is the complex scenario that we have in a legal system like India, where a judge has to manage the boundaries between general law, would be the Constitution, the Penal Code, the Criminal Procedure Code, and so on, yeah, and the various personal laws. So it's extremely complex and requires all the time this navigation, which we so easily misunderstand as deviousness, as, problematic. But it's actually a very important device to achieve justice. So that's one picture I wanted to show to indicate the complexity of this. So in this drama, in this process of trying to find justice or trying to find dharma or sharia or whatever, one term we're dealing with in Sanskrit, and that is vyavahara. Now, vyavahara, I asked one of you in the morning over a cup of tea, and Mahesh, I don't know where he's sitting now, but he was brilliant. Without prompting, he told me, in Kannada, vyavahara means business. Any form of business, he said. Is that right? Any form of business. Legal business too, but any form of business. Oh, okay. And so I said, yeah, but does it have other meanings? Does this word mean other things? And he said, no. And then I told him that in Hindi, vyavahara means behavior, action. Ideally, correct action. So it has a different meaning in that language. But what does it mean in Sanskrit? And now we come to Sarah's point. The Sanskrit word vyavahara was translated by Kane in his time, decades ago, all the time as judicial proceedings, nothing else. So we got this image through colonial consciousness, yeah? This distorted image of judging, witnessing takes place in formal scenarios in front of courts where you can bribe witnesses and do all sorts of things. That, I'm saying to you, is not the complete picture. In Indian law, and this is so relevant, I think, for your project, Balu, because Indian law is not only about courts and judges and witnesses, it is about the wholeness of the various legal processes. So I need to take us now to my model, which I yesterday showed you on paper, of the complexity of law. So there are 4 different types of law, and my argument is, and I will stop in a moment, Nomi, my argument is that these processes of vyavahara take place in all these corners. And maybe even at the same time, when a case goes to court, the person concerned will still try and find a solution. The person concerned in his or her village will still try and find a solution at the same time as the court proceedings are waiting or going on. And of course, nowadays, in international law, we might even have all sorts of implications also at international level. So it is extremely complex, and we are forgetting, ignoring, that all sorts of court proceedings are not the only type. And significantly, when lawyers talk about dispute processing, can you see we're cutting out informal processes? We're only focusing on formal processes. This is not good enough. And we need, for the project, Balu, we need to take into account all of the whole range of these different types of processes. Otherwise, your conclusions will not stand. I'll stop there.
Thank you. We have some responses from the panel specifically on that, perhaps. Stephen?
Try to make a few remarks. that I hope will advance the discussion a little bit. These have more to do with, I think, the position paper and what Professor Balu said just now than with what Professor Minsky said just now, which I hadn't heard before. But so I guess I would want to start by acknowledging, as I may seem not to have done yesterday, a cultural difference in which, in certain contexts, in India and some other places, there is, let's say, a routine practice of witnesses lying. I take it that's what's been claimed, and I think I was resisting that some yesterday, but on the basis of more knowledgeable sources, I'm going to accept that that's true. I'll just say parenthetically, I'm still not sure that a distinction between lying and deception is, to me, very helpful in understanding what's going on here. I suspect that perceptions of oppression and imposition still have something to do with this, quite a lot to do with it. I also think, as the position paper suggests, that a sort of Western commitment that probably has waned considerably in recent decades or centuries of taking oaths very seriously, with the view that someone who lies under oath is likely to go to hell or something like that, is probably a fairly important part of this background as well. I think that's consistent with what Balu said. But whatever the explanation is, I take it as a fact then that there is a significant cultural difference here. And I think that fact then does raise some really interesting and hard questions, some of which I think go to the kind of transcendental question that Balu was talking about just now. So just to see how this would work out, imagine we've got two legal systems. We'll just unimaginatively call them A and B, legal system A and legal system B. And both of them have procedures that rely heavily and centrally upon the testimony of witnesses to try and figure out what the facts are and what conclusions should be reached and so forth. Both of them are similar in that respect. But in system A, the expectation is that witnesses will tell the truth, that they will answer, and the assumption is that they usually do. Sometimes they don't, but that most of the time, witnesses, when they have sworn to tell the truth, actually do tell the truth. Now, everyone knows there are certain situations then where they don't tell the truth, where they perjure themselves, and some of these are even perhaps thought, although people don't want to express this very openly, to be justifiable. The case we mentioned yesterday of a situation where the police have really good reason to know that, the particular defendant is guilty, but some of the evidence has been excluded for one reason or another, witnesses have died or whatever, so they they manufacture evidence in some way, or they persuade someone to say that he saw the crime committed when this actually isn't true. This happens once in a while, and it may even thought to be justifiable. Naomi was talking about sort of a famous case in the U.S., the Ted Bundy case, where the police manufactured some evidence to convict a known serial killer. That might be a case in which people might think there's some lying going on there, but this is one of those rare cases where it's justifiable. In legal system B, by contrast, witnesses routinely lie. There's an expectation, there's assumption that they do this routinely. And this is sort of widely known. It's a fairly notorious practice. Now, it would seem to me that if you start thinking about system B, that the whole procedure of bringing witnesses to give testimony about what happened would come to seem quite pointless. That the whole use of witnesses would lose its function. Would lose its function. If everybody knows that witnesses are just saying whatever they've been paid to say, then no one's going to believe them. What is the point, of bringing people in to testify? The more general point here, which I think is consistent with something I was trying to say yesterday, is that the argument would be that even lying is parasitic upon a norm of truth-telling. Lying really can't sort of perform its own function except against a background in which it's normally assumed that people will tell the truth. Otherwise, it isn't even possible to lie in any effective way. So you might expect that this kind of system would very quickly then collapse. or at least it would be drastically modified so that its reliance on witnesses would disappear. But what happens, or what are we supposed to think if in fact this doesn't happen? You know, if in fact the system nonetheless persists, you know, year after year, decade after decade, with everyone understanding basically what's going on. What should we make of this? I think there is an analogy here, and I'm not making a direct jurisprudence point, but only an analogy, to a problem that's arisen in thinking in US law from positions that see law as being radically indeterminate. There was a movement back in the 1920s, 1930s called American legal realism, and again in the 1980s into the 1990s, critical legal studies, that sometimes, and in some of its more enthusiastic moods, would claim a kind of radical indeterminism. The idea is, you know, that the rules of law are so indeterminate that it's basically possible for judges to reach any decision they want in any case. There'll always be a plausible legal argument for any conclusion that they might want to reach. So the argument, just to break it down a little, is legal doctrine purports to dictate the outcomes in cases, but in fact it doesn't. It doesn't determine results. Judges make their decisions based on other factors, psychological factors, political factors, whatever, and then after deciding how to come out, they spin out some legal rationalization to justify that result, which they can easily do for any result that they may happen to reach. That's a maybe somewhat exaggerated view. Not too many people pushed it quite that far, but sometimes in legal realism and critical legal studies, it seems as if the radical indeterminacy is pushed to almost that point. And so then the same question arises, I think, that we have with the legal system B. You know, what's the point? What's going on here? You know, if it's sort of understood that the way the system appears to work is not at all the way, in fact, people understand that it does work, then why does it continue? Now, I think that some of the answers that were given to the indeterminacy point might carry over to this question about witnesses. So one possible answer is it's a matter of public legitimacy. People involved in the system know it's not working in the way that it purports to do, but the public generally, you know, the system needs to justify itself in the eyes of the public generally. They think it's working in that way, and so we have to maintain that appearance, even though we, those of us who are, you know, actually participating, know that it doesn't really work that way. As an empirical question matter, that's questionable, I think. And it's also doubtful, I think, that could continue for very long. And, you know, there could be such a gap between what people involved in the system know and what the public knows and so forth. So there may be some plausibility to that, but there are real limitations to that answer. Another kind of answer, I think, is that there's a kind of double think going on, even among the people who are participating in the system, a kind of self-deception. Duncan Kennedy, one of the critical legal studies people, developed this to some degree in a book he wrote in about 1990, and had some interesting things to say about self-deception. So even the judges convince themselves that they are operating in accordance with the law. At one level, they convince themselves of this, even though in another sense, at another level, they know that this isn't so. And lawyers and the public generally may all engage in this kind of doublethink. So that hypothesis raises some questions as well. One is how this works, and here I think you get into this paradox of self-deception that comes up in lots of areas of life. It's sort of familiar. And I, for example, just to give a sort of a homey example, like I suspect a lot of people, tend to set my clock 5 minutes ahead so that I won't be late for things. But of course I know that I've done this, you know, so why does this work? I mean, I know my clock is 5 minutes fast, so why does it work? And yet somehow it does. I somehow manage to forget for some purposes that I've done this, and it helps me to be on time. That's just a very small example. But this sort of paradox of self-deception is an interesting one, I think. But it may be that that's going on in law with indeterminacy, and it may be also that would be some account of the cultural sort of phenomenon with legal system B. Last one I'll just mention, maybe the system is not as indeterminate as we sometimes suppose. Maybe the corruption is not as massive as Balu has suggested. All of these answers, though, seem to be somewhat problematic, and this system seems somewhat unstable. So I think there is a lot of room for research here and investigation, like how close is the Indian legal system to System B? I mean, is that actually the way it is? And if so, and to the extent that that's so, how could we account for this very puzzling phenomenon, I think?
I see that we're in a style of, which has been fascinating so far, a style of presentation. We could also, if you feel the need for a different style, we could move to more of the exchange, the smaller points, yes.
Go
ahead.
Thank you, Naomi. I can do bullet points. Well, I appreciate all the presentations so far, and of course I have to agree with Werner that there is a much larger context to what we are talking about here, right? And also, in fact, your intervention directs us towards the possibility of investigating what indigenous or whatever native or Indian Indic concepts may be at work in the background process, even within the formal systems. And if we simply stick to the formal context for the moment, with which Balu has primarily been concerned in his paper, I assume that the concern was directed in your paper to the formal system because that is where the colonial consciousness in a way holds sway the most, right? And also because the legal academics and so on, I think you also observe this, have not been able to explain why the system is functioning in that way. So that is another, if you like, legal academia and so on also becomes a site for colonial consciousness where the real experience in courtrooms, the formal courtrooms, it has not been theorized. No, people don't know why that's happening, or they haven't explained. Maybe they don't want to admit that. Now, I draw some inspiration from what Balu observes in his paper about the distinction between the role of the judge in the West and the non-West, or in the Indian context specifically. And I find it quite fascinating because it speaks to a recent experience of mine. So I will just go anecdotal now, from bullet point to anecdotal. Balu basically observes that the role of the judge in the West is to find law. Right? I'm abbreviating his argument, obviously, is to find law, right? So, but the judge must have only limited discretion, or preferably no discretion at all. And it's the law which does justice. The judge applies the law, but it's the law is there to do justice, right? So it's the framework of legislation, constitutionalism, and so on, which is extremely important in a Western context. Now, that framework has been transplanted. The assumptions behind those framework, let's assume, have been transplanted into the Indian context as well, where Balu says the role of the judge in India is to do justice, is to have discretion, right? But to me, it's very interesting. I mean, I'm also drawing on observations that Werner makes you make in your own writing about judging activity in the Indian context and so on. And it's very interesting because Werner's research shows us in the formal context that India has imported the doctrine of precedent, for instance, right? So one judge should follow the other judge and so on. There is a kind of line of authority. Werner argues, I think you do, don't you, that that breaks down in India, right? That the doctrine of precedent, so one judge doesn't actually follow what the other judge does.
Sometimes yes.
Right? Yes, sometimes no.
Yes,
Yeah.
sometimes
So, but in several areas of law, several fields of law, Werner shows us that you get different lines of cases developing on the same subject, right? In the same field, but and those lines of cases can largely be explained by the background facts. And
I think we established yesterday already that the systems like the Indian system work from case to case.
Yeah.
Every case is an entity in its own right, to some extent.
Yeah. So this
But
is
there is this awareness, there's also precedent, there's also statute, there's also the Constitution. Judges are bound by the Constitution, come on. Yeah, they don't have total
so
discretion.
this is dharma-ness or neo-dharma or something.
Oh, it's a messy mix.
Yeah, messy dharma.
Messy
Okay,
dharma.
is going on, right?
Yeah.
Within the formal context. So that's one. The other thing is that very striking, and I've been having conversations with various people, Vahida included, right? I can't see you, about the tremendous activism of the Indian judiciary over the last, let's say, 25, maybe 30 years or so, maybe slightly longer, since the emergency period especially. Huge level of activism. A level of activism which Western judges look at and get scared. They shake when they see how activist the Indian judges are. And you can see similar patterns developing in South Africa and so on, which are extremely impressive, I think, from a kind of jurisprudential perspective, right? So how comes these judges are able to, how comes they feel so emboldened to act in this way? Yeah, so interventionists, right? Calling government departments to account and all kinds of things. Kalindi has done some work. I haven't looked at you. Where are you, Kalindi? Yeah, hi. You have done some research, right, which you're going to tell us in the panel tomorrow, right, about how ostensibly applying Muslim law, right, under our personal law system, judges in local courts in India are actually applying Hindu law, right? And that tells that's so suggestive to me, yeah, that the framework which the judges are really applying is one with a high degree of indigenous sensitivity in a way, right? And so the kind of distortion you're talking about will also tell us, like Sarah was telling us today, about suggestive lines of inquiry into how judging activity actually takes place, taking into account indigenous legal postulates, right? So these are all varieties of situations where we can see certain things happening that need explanation, right? And one could do a lot more, right? So of course the corruption thing is there, right? But there's all kinds of other nuances here which show us a very kind of bumpy picture of what's going on happening within the Indian justice framework. Okay, I'll stop there. I actually wanted to tell the story, but I won't now.
Yes. You know, I'm going to hew fairly closely to the document itself, which I also hope you have read, so that it will enable you to follow along with me. And, you know, I have to apologize to Balu in advance for deviating from his prescribed methodology, because, in fact, I find it impossible to read this document, which describes a difference between legal rationality in the West and whatever form of law we have in India, without thinking of Weber. And I find it impossible to read his account of transformations in law in the medieval period without thinking of alternative accounts. And so my proposal for methodology would be to compare what he has presented to alternative accounts that are really there, which he may have in mind, but which are not cited in the context of a very short paper. And comparing his account against those accounts, I think there are some notable absences in his very short, sketchy explanation. And I'd like to elicit the points that I think are most worth noting. So in the first place, it seems to me an exaggeration to say, as he does at the bottom of paragraph 2, that the transformation from, say, trial by ordeal to trial by inquisition or jury was motivated by a desire to respond to the fact that witnesses who were truthful were reluctant to come forward. This whole period was massively complex. It's been discussed by not only Harold Berman, but also, of course, Max Weber, and more recently, Charles Taylor, Peter Brown, and others. And there are at least 3 moments of transformation that are going on during this time period. One is the rationalization, as Weber called it, of canon law, which for Weber stood as the paradigm for legal rationality, which, as we know, is also a synonym or near synonym of bureaucratic rationality, and as such describes one of the poles of the binary that is described by charisma and its routinization. Another is, and let's just leave that aside for now, what legal rationality means. I'll talk about it a bit more later. The second transformation was the demise of the supernatural. So Peter Brown brings this out also in the way in which, you know, we think that the Reformation brings about the demise of appeal to supernatural forces, but it's actually the Fourth Lateran Council in 1215 that begins to crack down hard on trials by ordeal and substitute more official procedures. And the third movement, which has been discussed especially by Charles Taylor in A Secular Age, for example, is the rise of confessionalization. Now, that is to say that more requirements are placed upon Christians who are members of the laity and not of the priesthood to be more observant in a more rigorous and prescribed way, including the requirement to take communion and to take confession. Now, why is this relevant for the whole question of, you know, truthfulness or supposedly being emphasized within Western traditions? Because the emphasis on interiority, the emphasis on sincerity, is something that we can already see emphasized within that movement toward confessionalization. discretion to extend that to the laity. Now, I would just refer you to Charles Taylor's account if you want to know more about that. Now, there's much more going on here than Balu suggests, and some of it actually, I think, supports his argument, although he doesn't talk about it, such as the emphasis on confessionalization. But the question of rationality of Western law certainly emerges out of this period. And it's looming as this kind of specter over, I think, Balu's paper, at least as I was reading it, that's what I was thinking of. Because, of course, for Weber, this becomes the paradigm for arguing for the uniqueness and perhaps the qualitative superiority of the West. Now, let me move to a later moment briefly and address the issue of the arbitrariness of the Indian judge as Balu sees it as being contrasted with the role of the judge as hewing closely to legal procedure in the West. This ignores the fact that much of the debate in law reform in the West in the last few centuries has turned precisely on this point. And the locus classicus for this would be Jeremy Bentham's critique of William Blackstone in Bentham's comment on the commentaries, where he criticizes Blackstone's argument that the judges of the common law are like oracles. They pronounce decisions in an oracular way. It's as if they come out of thin air. And there's no reason to it. And this is actually what motivates his proposal for legal codification. So, of course, we have this model of an arbitrary judge who instantiates or embodies the mode of what Carl Schmitt later calls legal decisionism, as contrasted with a model of bureaucratic legal rationality, which is conversely instantiated by or exemplified by Bentham's codification proposal. So when Balu talks about the rationalization of the judge in the West, what he's really talking about is the ascendancy of the Benthamite model. But one should also be aware that there continues to be a contestation over the relative roles of decision versus legal rationality or normativity. And those debates more recently have occurred in connection with Schmitt's critique of Max Weber. So I think all of this is a way of trying to introduce a little bit more nuance into the very outlined schematic history that Balu has presented, which also I think has to be complicated by the fact that there can't be that utter contrast, because both strands that he describes and uses to categorize India vis-a-vis the West, that is to say, our legal arbitrariness, judicial arbitrariness versus legal procedural rationality, both strands are in fact present in the West in different ways and remain as points of contestation even into modern times, which I think begins to interrogate this binary that he's established in a way that might hopefully aid the task of legal translation between the two different cultures.
Thank you. Yes, oh, Prakash. Yes.
Yes, this might be an appropriate time to remind myself of the story that I was going to say. I mean, this is where, perhaps in relation to Robert and Werner's observations, I would place the emphasis slightly differently based on this story. Now, I've been engaged in this project on law and religion recently, currently, and one of my tasks was to write up the kind of research results, and they range across a whole variety of different areas, right? So this is law and religion, religious diversity in the European context, and so on. So I've more or less accomplished the part on family law, right? And one of the things I tried to put forward as a suggestion is that we should empower the judges more in Europe, right? We should empower the judges more so that they do have discretion to do situation-specific type of judging and justice dispensing, if you like, right? And I hadn't realized the force of Balu's suggestion at that stage. But then I got some feedback from one of the co-participants in the project, and his feedback kind of revealed to me how scary that situation of allowing judges to have plenty of discretion is for Europeans, right? Because he said, this would be completely chaotic if you allowed judges, right? And of course, we're talking about ethnic minority or religious minority contexts within the European situation, right? So you have a framework of law, which is, of course, it's a kind of secularized form of Christianity as applied in family law, right? And it usually creates problems when you're, applying that kind of legal framework in a highly, culturally diverse context. And hence my argument for judicial discretion, right? So that they could actually balance and decide according to the facts and circumstances of the cases, and also take into account the cultural background of the parties that are coming before them. But it doesn't look like that's a very palatable solution, right? We want to hem judges in, we want to tie judges into a kind of strong rule-oriented framework still today. So I think this is where there may be aspects of both things. Yeah? Of course, there is judicial discretion, right? But it seems like, like in yesterday's example with truth and falsity, it seems like, or rather lying and deceit. The moralism, the moralist or the ethical dimension is actually doing the driving, right? And that's maybe, okay, I'll stop there. Yeah.
I'm more interested in tracking the disagreement to their source than resolve the disagreement, because this is a particular kind of problem I keep facing with my stories when I discuss with Western intellectuals. First of all, I apologize. I mean, I'm not an expert in law. I'm struggling with this problem. I haven't quite yet figured out how to tackle it. But I don't see why there is such For example, when Werner says the notion of law is important, jurisprudence is important, I never said it was unimportant. I said it's not relevant for my purposes today. And I was making no general claims about whatever its relevance or otherwise to the entire project. This is a trivial misunderstanding, but this can be easily clarified. Perhaps the best way to do it is this, to sketch the abstract, two ways, abstractly, what the problem of comprehension is. Let me take the example of Steve. System A, System B. His System B requires modification. Their witnesses do not lie all the time. Perhaps they don't even have witnesses. So I'm very, very aware, in fact, that is the point of the whole exercise, that there are many indigenous sources of settling disputes. For example, Dharamasthala is one such wonderful example. And the courts direct the litigants to go to Dharamasthala to solve their problems. And the decision of Dharamasthala is legally binding. Now, we know all these things, you see. So we don't need stories about this. I'll tell you what the problem is. Let's take System A, System B. Look at them abstractly. System A, let's say, is a Western institution of Western legal institutions. System B, institutions, indigenous institutions, India has been using this, not one, there were many. Maybe they had similar structure, different structures, for millennia. These are two different structures. Here is what I am focusing on. Not on indigenous system, not on the Western law. I'm asking the question, what happens when this Western system is superimposed on the indigenous system? What happens to me is distortion, and that is what I'm focusing on. That is what I need to understand. It has nothing to do with the complexities of law. I'm very aware of it. I can add another 50 dimensions to what Vernon has drawn there. But that is not interesting. We haven't figured out what the problem is. You do not complicate something when you cannot solve it. This is the useless historian way of talking. Making everything complex, adding 550,000 million different dimensions. Doesn't solve it. Scientists work differently. If a problem is complex, simplify it, reduce it, break it into parts. Well, that's how I am working, because I'm a scientist. I'm not a historian. So kindly don't keep on adding nuances, because it's a worthless, absolute waste of time. Personally, it irritates me. Because the question is not that. We all know the world is messy, the law is messy, human situation is messy. We know it every day. Why repeat that in a conference? You're trying to figure out the problems. So you have to simplify them, reduce them, split them into parts, handle what is, make it tractable. That is what you have to do, not add complications. So first thing is, so System A, System B. A is superimposed upon B. As a result of which neither A is functioning nor B is functioning, a distortion comes into existence. That is the situation in India today. May not be only India. I don't know. I've studied only India. So I'm talking about the West in order to see what kind of a system is it that has come to India that's creating distortions. The second problem that complicates, obviously this point I'm failing to get across. There's a second point. Because of I failed to get across this first point, I'm failing to get across a second point. Suppose I say there is a difference between a castle and a cathedral. Here is the kind of argument I get back. Yeah, but it also has a mirror, it also has a window, it also has bricks, there is also mortar, there is also cement. Yes, please, we know all that. But do you see, one is a castle, the other is a cathedral. No. It also has steps, there is also floor, there are also walls, there is a ceiling. Yes, we know all that. So I fail somehow, I don't know how to do it, in telling the people, look, we use the same material, one is a castle, the other is a cathedral, the third is a mud hut. Let's find out what is going on here. I fail in that. So everything that has been told so far is to say, there is also this, there is also that there is also, this also happens in Europe, there is also some arbitrariness here, some arbitrariness here. Yeah, right. Then the only thing I can do is what I'm now going to do. Ladies and gentlemen, keep quiet.
Would it help? You framed a question at the end of your opening remarks in which you said that you wanted to know how was such corruption possible. Would you like to get back to perhaps that?
Okay. Let's see how well it goes. I've put across another kind of problem modifier, so maybe we can
Okay.
use it as a model to
Okay.
focus the dialogue.
Go ahead.
Can I say a little?
Yes.
I had thought that my legal system B might present the kind of problem that Balu is interested in.
Where witnesses don't habitually lie in system B. This is what you're saying.
Well, let me put it this way then.
That happens when the distortion occurs.
If suppose that, as someone told me yesterday, you have a legal system in which it is understood that witnesses can be bought and they lie all the time, and that the decisions are actually made by judges who know that the witnesses can be bought and they lie all the time. But nonetheless, this sort of system persists.
That's a procedural law.
Right. But so one would wonder, and I think I'm asking the same kind of question that you are. What's going on? How would you explain this sort of thing? Maybe not. But
this is why I'm trying to figure that out. That's why I brought in truth, deception, honesty first. See, it is a ridiculous example I'm going to give. The witness who would swear on Ganga and lie in the court, the same person, were he to come to Dharamasthala in front of Manjunatheshwara, he would not lie. This is the difference.
right.
So can we then ask why that person would not lie in one scenario but lies in the other?
This is a useless question, Werner. This could be million reasons why he doesn't do it. An individual, we're not interested in the individual. We're interested in the social phenomena.
Yeah.
So, why means what? Why does an individual lie? For 100 reasons. Maybe he had a stomach ache that day. Who knows? Who cares? That is not the issue. Why is it witnesses in Indian courts, Western courts, are unreliable is the question. Not why they lie. One of the reasons I'm already formulating is that the courts are a context where the idea of a true witness, the way it exists in the Western thing, simply doesn't function in India. And I try to bring in the notion that lying is not a moral issue. But lying in front of Subramanya or Hegde is another issue altogether. There's nothing to do with truth or lies there.
Okay, agreed.
Well,
So, is that the end of the question?
It is the beginning of one.
Well, the question that I thought, or at least one of the questions that arose from this, is not just why does the witness lie, but rather why does the judge continue to operate under what looks like a kind of a sham?
He doesn't care.
Well, Well, here's a hypothesis. The judge, for example, thinks, even though I know that these witnesses are not a reliable source of any kind of truth as to whether this defendant is guilty or not, there are other things going on behind the scene, maybe more traditional things, like the police functions. I don't think the police would bring somebody into court unless they had good reason to know, that this person is guilty. So this, and this is where the imposition, I thought, came in, because you say...
You don't know how police function in India. They bring somebody to the court for all reasons except that he's a criminal. Let's understand something here, people. Let's understand something here, people. See, there are two ways of, that is how Werner, Steve are all asking questions. Let's abstract, just think of the word corruption. Now, corruption is a problem even in Europe and America. We all know that, right? It's not confined to Africa, Asia, Latin America alone. It's also a problem there, but they have recognized it only in the last 35 years if you go according to the literature. Good. When the Western theorists, whether in political economy, whether in sociology, whether in law, wherever, they try to tackle the issue of corruption, this is how they frame it. Why does some individual or another violate certain rules of public service? So then you give a psychological explanation, psychoanalytical explanation, object theory explanation, whatever you feel like, you give it. But when we say corruption, we use the same word in India. We are not asking why some individuals, in contrast to others, is corrupt. To us, it's a social, massive social phenomenon. Let me exaggerate it to the maximum. Why maximum? 3 weeks ago, there appeared a newspaper article doing statistical survey, says that more than 55% of the Indian adult population is corrupt. Which means what? Either your father or mother is corrupt. It's as simple as that. Half the audience here is corrupt. I mean, I'm using statistics in a very funny way at this moment when I make this transposition. This is what we are trying to understand. Not why 1 in 10,000 takes bribes. Why is it out of 10,000, only 1 person doesn't take bribe? That's what we are bothered about. 9,999 takes bribes. It is rational, it's normal, it's moral. So this is the phenomena we're trying to understand. So don't come with psychological, vague sociological explanations because they don't work. So our police system, our judiciary, police take somebody because the politician tells him, go give him some kicks. So he takes him, puts him in the jail, breaks him and kills him. How many do we not know that? In every state in India it's happening. Police don't like somebody, go get hold of the bugger, put him in jail for false grounds. They manufacture evidence like nobody's business. That's what the police do. Police are seen as legal gundas by citizens. This is what we're talking about in India.
Well, if that's so, I wonder whether you're answering your own question, in other words, then. I mean, if we said, in other words, let's just take a case where the police bring someone in and accuse him of murder, and the prosecutor, then pushes the prosecution accusing, so-and-so of murder. Some witnesses come in, and they say, yes, we saw him commit the murder. The judge ends up convicting the person, and he's sent to jail or whatever the punishment is that's imposed. Now, if we could, off the record, in some way where the judge could be counted on to tell the truth and disclose everything, has no reason to, and say, what were you doing in that case, and why did you convict that person knowing that they'd be sent to, it seems to me that there'd be a variety of possible answers I can imagine, but there are probably others that I can't imagine. I mean, the kind I was imagining that I take it now you're saying is probably not accurate would be to say, even though I knew that the witnesses were totally unreliable, they're just paid to say whatever the police want them to say or the prosecutor wants them to say, I assumed that the police probably had good reason to believe that this person did commit a murder, and that's why we went through this sort of procedure. Now, I take it you're saying that probably isn't it. There's probably some other political or social reason. But fine, okay, maybe there's some other reason that the judge understands what to a Western eye would look like this legal procedure of using witnesses to find the truth and it not perhaps working very well is actually something totally different, where we're using certain forms that have been imposed on us, but nonetheless we're using them to achieve ends and perform functions that we understand perfectly well. And if that's right, then maybe that's the answer to the question you're asking. If you say, why is there this sort of massive corruption? You say, well, because it's serving some other function, but the people involved in it and the people who are part of the culture understand what that is, and that's what it's doing. So then I'm not sure what the remaining unanswered question would be if you know all of that about it.
Can I come back to a comment you made, Balu? You said if somebody goes to the Dharamasthala, they would not lie, and there would be a
ridiculous example, I said, yeah.
Sorry?
I just said I took a ridiculous example, but
Yeah, okay.
I've not known it happening, but I've just assumed.
Yeah, okay, but looking at this picture here, the drama scenario would be closer to corner 1 than to corner 3, because you're dealing with a religious or ethical or moral or whatever institution. You don't think so? Yeah? I would locate that closer to corner 1, whereas your state court would be in corner 3. And your observation is once this dramatic scenario is in corner 3, something doesn't function within the Indian system because it is transposed from the West. So is your argument, in a sense, that India would be better off without those Western transplants?
How can you abolish?
But you're engaging us in a legal debate,
I'm
and you're
not-
asking all these
I'm
questions.
engaging in a philosophical debate, not in a legal debate, because you're discussing no legal statutes. We're discussing maximally jurisprudentially, that's all, not legally.
Okay.
See, by simply putting it in some place or another in a kite doesn't solve our problem, does it, Werner?
But it makes it
Does
clearer
not.
what's
It's
going
like
on.
it's like the social scientists in 60s, 70s. Simply they drew boxes and drew arrows. It goes from here to there. Fair enough. It goes from here to there.
Yeah.
Okay, it's on this corner or that corner in the kite. Fair enough. But the point is this: Western legal institutions are here to stay. We have indigenous structures, most of whom cannot tackle some kind of problems which Western legal institutions appear to tackle. We have a problem of the interface between these two systems. And it is these that is breeding corruption, distortion, disintegration, and so on. So we're trying to figure out what kind of an interaction is it between these two structures and what could we do about it. You can't solve it by saying it's in this corner and that corner, 50 different corners.
If I could, you just said something was the source of the corruption.
Because of the two systems are superimposed on each other.
That's what causes the corruption. Robert?
Again, I have to apologize for speaking historically, but I wanted to address at least this general question of superimposition of Western categories on India and in Indian law, and also get back to Werner's very important point about the translation of Vyavahara. You know, it's also the case that in the late 18th, early 19th centuries, Western scholars were translating that term as custom or as procedure, or sometimes simply as law. And when they did this last, as I've written about, they were tendentiously, in a biased fashion, identifying Vyavahara as the whole of law, the entirety of law. Whereas there were two other branches historically of Dharmashastra, namely Achara and Prayaschita, or what we might call ritual and expiation. And when we add those other branches back in, what we also get is something more like Werner's poll number 1, and this idea of dharma as being ritual ethics or law plus religion or some such, in which total system, as I read it, there were also requirements of honesty and truth-telling, at least as they were stated in some of the classic texts like Manu. So, for example, one of the forms of, also you could call this trial procedure, but it's like related to the divya, or the ordeal, as the shapata, or the oath. So oaths were taken. You know, oaths had consequences, and they were taken according to one's caste status. And, you know, so in that sense also it seems to me that there isn't necessarily this contrast with the West. But when you see that embeddedness of what we think of as a kind of truncated law, which has been reduced to this bureaucratic procedure, the embeddedness of that formerly in a complete system of ethics and a cosmology, which was also an account of the person and a notion of salvation, and of right conduct. That's where I would identify one of the deleterious consequences of the imposition of Western categories on Hindu law. And even into the 19th century, you had some traditions of teaching the entire canon of law that included those other elements that were excised, like the achara and the prayaschita. So I think when we talk only in terms, for example, of witness and judge, aren't we in fact reducing what dharma is to the categories of Western law? Isn't that done by the terms of Balu's paper? And so I don't want to do it in those terms, right? I want to think more broadly about what it means when we try to translate a term like dharma into law or to impose the category of law on that of dharma, because that has had profound consequences in so many ways.
I think, Bala, what your suggestions do not account for is the possibility of choice, because there are, within the structure that I have on the board here, there are subfields which people choose. It is not that automatically every judge or every witness will be part of the state system. I mentioned yesterday the coexistence and the need to find the right balance between more state and less state. There's massive avoidance of state law in Indian law. And there's massive avoidance of state law now in Britain because we have so many Asians there. Because they do the same thing as they do here. And we find this problematic in Europe, and this is your Religare project. Yeah? But are we getting you wrong, Balu? I still don't understand.
No idea. Let me think about it. Let's think.
Because you've pulled us into this plural scenario where you want to make us talk about the conflicts between these competing fields.
The strange thing, Werner, is this. I have a feeling I understand you, but somehow I get the feeling I'm failing to get across to you. You see what I mean? I can't say you don't understand me. I don't know about that. But I keep getting the feeling I fail to get across to you. I see the point you're making. I understand them. But that is not what I'm talking about. I'm pointing at something else, and obviously I'm failing in it. But the strange thing is, Indians see it very quickly.
Yeah, because Indians see this plurality. And they strategically choose. They choose. Yeah? And they don't like the Western system.
No, that's not true.
The lawyers like the Western system. Of course, it makes money. Come on. It's vyavahara. It's business.
No, we're not up to the audience yet. We're not at the audience. So, judge right now, down, please.
Robert.
A quick comment here. So here's a sentence from actually the next to the last sentence in this section in the position paper. It is almost as though one is denying the daily experience of a people in order to embrace an alien experience which can never be one's own. So when I read that, I thought that I had no objection to that. I have underlined it here, and it seemed like something that might well be right. I don't think I have standing to know for sure whether it is right, but I take it on the testimony of others who are more familiar with it that might well be right. In the course of this discussion, I started to wonder, though, whether that is right, even in your view, because I've sort of come to think that I'm not at all sure I'm understanding this right, but that this system, well, it's almost as if from a Western perspective, this is what it would look like. The superimposition, the imposition upon a foreign system, of a different system with the distortions that creates. But in hearing you talk about it, it sounds more like as if from the perspective of an insider, actually it is serving some quite different function, but...
yeah, it's making the police and the judges rich, yeah.
Yes, and the issue of bribery is an important one for you in this. No?
No.
No?
The problem is not whether a group takes bribes and the other one gives bribes and so on. We're talking here about institutions with, let's say, at least 1,000-year history in Europe. We talk all of this without problems about something called the rule of law. Everybody promotes it everywhere else. India goes jumping up and down everywhere, how it is a democratic country, how there is rule of law here. Now we have to figure out what we're talking about when we use those words, don't we? So the more I dig into law to find out and see how, for example, Belgian institutions of law are working, and I see what's happening in India, you see something, it is a very distorted image that you get here. It's neither functioning according to the Indian judicial, Indian ways of solving disputes, nor is it functioning the way as an imperfect judicial, legal institution from European culture. Yeah? We have here massive debates, you wouldn't believe it, such as the level of the literacy of our politicians. When a court quashes a law on constitutional grounds, they jump up and down saying, but this is democracy, people are the sovereign. Obviously, they don't even know the difference between having a constitution and being like Britain, where there's this talk of sovereignty of the parliament. So and everybody goes around making rules. If you are in a position, they think you make rules. Just think of the vice chancellors. They just go around making rules as it pleases them. And everybody obeys them because they are the rules. So there is a peculiar thing that's going on in India, probably also in other Asian countries, and we have to understand that phenomenon. And I think it is basically a cultural phenomenon that has to do with how they deal with certain things, how they deal with certain things that are used in the Western institution in a different cultural way. That is a thing I'm trying to probe now with respect to law. I've seen it already with ethics. There at least I'm much more clear. With religion, I'm much more clear. About politics and about law, I'm beginning to get clearer now. And there you find these distortions beginning to occur because of superimposition. So I was trying to grasp the phenomenon of corruption through the categories I've used here: truth and falsity, judge and witness, and notion of a legal fact.
So we very clearly have in India a hybrid legal system, yeah? And this hybrid legal system yields a rule of law that is not the rule of law that you see in Belgium, for example. Because rule of law means different things in different places. There isn't one rule of law. And first of all, there's not one law. So we have so many different meanings of law. We have so many different meanings of rule of law. So why are you torturing yourself and us here?
Now that is an important question.
Let me make a suggestion. To end the torture, what say we go and have a cup of tea?